Ladies and gentlemen, hi, welcome to lawcaseuk.com. Today I'm going to be looking at the case of Horncastle and the United Kingdom in the European Court of Human Rights. Fairly shortly after Horncastle was decided, the European Court issued a press release that suggested that Horncastle represented the conclusion of a judicial dialogue that's taken place between the European Court and the domestic courts of the United Kingdom, in particularly the UK Supreme Court. And it's this dialogue that I'm particularly interested in looking at for the purposes of this video, but I'm going to use the case of Horncastle in order to allow me to review what had been said in the preceding cases. Now, the area of law that the case is concerned is the admissibility of hearsay evidence, and in particular the admissibility of hearsay evidence under the statutory regime introduced by the Criminal Justice Act of 2003. Now, that act sets out a number of gateways through which hearsay evidence might potentially be admitted. And there are two gateways under Section 116 of that act which are of particular concern for the cases that we're going to look at. And that's the gateway that allows evidence to be given when a witness is dead, or when a witness is unavailable to give evidence because they have a fear of doing so. And both of those gateways occur under Section 116. Those are the gateways that were considered in this judicial dialogue, but in particular they were considered in the context of hearsay evidence that might be considered to be sole or decisive. That is, the sole or decisive piece of evidence against a particular defendant. Now, because of the degree of weight that might be put on such evidence, the court, of course, has to consider the fairness of the trial under Article 6, in particular because of the inability of the defendant to test at court the evidence coming from the witness. At least they can't test in using the traditional route of cross-examination, quite simply because the witness is not present. Now, as you may recall, one of the minimum guarantees under Article 6, in Article 6.3, is that a defendant has the right to examine or have examined witnesses against them, and they can obtain the attendance and examination of the witnesses on their behalf under the same condition as witnesses against them. So there's a requirement generally for witnesses to be present, and in particular we would see that in the traditions of the common law, the adversarial system that we have in the courts in England. So the question then became in this dialogue whether the admission of this sole or decisive evidence under that regime in the 2003 Act could ever be compatible with the right to a fair trial under Article 6, and in particular whether the safeguards in English law were sufficient to guard against any potential unfairness that might arise. Now, those safeguards are also referred to as counterbalancing measures or counterbalancing factors in the judgments of the courts. Now, initially, the European Court, in a 2009 case of Al-Khawaja and Tahiri and the United Kingdom, appeared to suggest that counterbalancing measures would never be sufficient in a case of sole or decisive hearsay. But by the time Horncastle is decided, there seems to have been a softening in the approach taken by the European Court, and it's that change in emphasis that we're looking at exploring in this video. So the dialogue begins with Al-Khawaja and Tahiri against the UK, and here it was the chamber of the European Court that ruled that unless the fear that prevents a witness attending has been induced by the defendant themselves, it was doubtful whether any counterbalancing measures would ever be sufficient to justify hearsay evidence which was sole or decisive. So by way of comment from me, this appeared to suggest an absolute rule against admission and in effect defeat the purpose of the statutory scheme, at least in sole or decisive cases. Now, in the United Kingdom Supreme Court, in Horncastle, this conclusion reached by the chamber in Al-Khawaja was referred to as the sole or decisive rule. And when Horncastle was before that court, Lord Phillips said that it would not be right for the UK court to apply a sole or decisive rule rather than the provisions set out by Parliament. Now, he believed that the parliamentary regime could lead to a fair trial even where the evidence was sole or decisive, and he set out a number of reasons for his conclusion and for his suggestion that there was no need for a sole or decisive rule within English law. And he stated in his judgment that he hoped that the Strasbourg court might take account of what he had said in the future. And as he said this, he knew that the United Kingdom had already requested that the Al-Khawaja case be referred to the Grand Chamber of the European Court for further consideration. And indeed, the Grand Chamber delayed its own judgment pending the United Kingdom Supreme Court decision in Horncastle, so it would have the opportunity to consider what had been said in that case. But when it came to the Grand Chamber giving its judgment, it ruled that there was no absolute prohibition against sole or decisive hearsay evidence. So whatever the Chamber had appeared to suggest, there was no absolute rule against the admissibility of such evidence. The court, the Grand Chamber of the court, stated that where evidence is sole or decisive, a defendant's rights may be restricted provided that this is compatible with Article 6. And specifically, this requires sufficient counterbalancing measures to be in place which provide for a fair and proper assessment of the reliability of that evidence, and reliability becomes key there. Now, in particular, as the European Court cited in, or recited in the case of Horncastle, the Grand Chamber found that the safeguards contained in the Criminal Justice Act, supported by Section 78 of PACE, and the common law, that they taken together are in principle strong safeguards of fairness. Now, what was not recited in the judgment in Horncastle in the European Court was that also the Grand Chamber in Al-Khawaja had said that these type of cases, sole or decisive, do require, quote, the most searching scrutiny, end quote. So that's worth bearing in mind as well. So no general prohibition. Safeguards can, in some cases, be sufficient, but in all cases of this type, there should be the most searching scrutiny. So let me turn to look at the facts of Horncastle. So Horncastle has reviewed the earlier jurisprudence, but if I look at Horncastle itself, it actually concerns two cases, each with two defendants. In the first case, Horncastle and another, Blackmore, were convicted of causing grievous bodily harm with intent in a prosecution that was based upon a written statement from their victim who had died before trial. And in the second case, Mr. Marcus and Mr. Graham were both convicted of kidnap in a prosecution based upon a written statement from their victim who was too frightened to give evidence. So we see both gateways being explored here, death and fear, as we did in the earlier Al-Khawaja case. Now, as it frequently does, the European Court began by stating that the admissibility of evidence is primarily a matter for regulation by national law, whereas the European Court's role is to ascertain whether the proceeding as a whole are fair, and this includes, of course, the way the evidence is received. Van Mechelen and the Netherlands is one of the authorities for that proposition, but there are many, but the court refers to Van Mechelen. Now, the court then next indicates that when considering Article 6, the court, of course, will look not just at the rights of the defendants, but also the interests of the public, of victims, and where relevant of witnesses as well. So they look at the case in the round, and when the European Court came to apply the Grand Chamber decision in Al-Khawaja to the cases in Horncastle, it decided as follows. Now, for Mr. Horncastle and Mr. Blackmore, here, even if the evidence of the deceased victim was actually decisive, the court decided there were sufficient counterbalancing measures, which included, in that case, a careful direction from the judge, as well as the provisions that I already mentioned earlier when talking about Al-Khawaja. So here we see an example of a case where the evidence might be sole and decisive, and the European Court found that the United Kingdom's statutory protections and common law protections were sufficient to counterbalance any potential unfairness in that case. Now, for the second case of Marcus and Graham, the court decided that there, due to the other strong incriminating evidence that there was in the case, the hearsay evidence that was admitted was not sole or decisive, and therefore, in those circumstances, it was not necessary to examine whether there were sufficient counterbalancing factors at all. However, let me add by way of comment that under the Criminal Justice Act, an English or Welsh court would always have to have regard to the safeguards under the Act, even in a non-sole or decisive case. It would just be the extent to which the safeguards were required that would vary depending on the potential weight of the hearsay evidence. So there you have it, ladies and gentlemen, an example of a human rights dialogue between an international and a domestic court, one which does give rise to an apparent softening of approach by the international court, so that the statutory regime under domestic law remains, in theory at least, compliant with human rights standards, but which in practice may or may not breach Article 6, depending on how the law is applied in each individual case.